Good morning, Judge, and I know you slept well.
He didn't answer that.
Welcome back. And of course, we have, as a committee, I don't know that we've recognized your wife, Louise, but she's back and very patient sitting there. You mentioned yesterday that the confirmation hearing of your mentor, Justice Byron White, lasted all of 90 minutes. Yesterday's hearing was a bit longer, and I'm sure that you needed your rest, and I'm glad you had it. I was impressed yesterday both with your poise and your thoughtfulness throughout the long day. I came away with, I think, a greater admiration for you, and particularly how seriously you take your duty to give each litigant who enters your courtroom a fair shake, as well as for your commitment of judicial independence. And I've had an opportunity to comment to various journalists or TV people or radio people, and I have stressed your statements about independence. Before I start my question,
Where is this email?
I want committee members, those of us up here and the ones that aren't here, to understand that I'm prepared to stay as long as we need to so that everyone asks all their questions of the nominee today so that we can move on to other people that want to testify in regard to this nominee. So I hope that we can move things along and we won't have to stay a long time, but I'm willing to do that. And then tomorrow we'll have that schedule. I want also committee members as well as the nominee to know that when we finish the questions, we'll move to the regular committee room of the Judiciary Committee. That's just down the hall, Dirksen 226, for a closed session, as we have done with every Supreme Court nominee, I think, since Senator Biden was chairman of the committee, as I recall. Now I'd like to go to my questions, and as I said yesterday, they'll be 20 minutes long. Let's visit about judicial independence. Yesterday I predicted that you'd get asked a lot of questions that it wouldn't be right for you to answer. And unfortunately, I was right, and you got those questions from many people, maybe even people on both sides of the aisle. A lot of these questions concerned issues that might one day come before you as a justice. And as you very clearly explained, it would compromise your independence if you pre-committed to how you'd rule on future cases. It would also be unfair to the future litigants, and you made that very clear. And of course, there's nothing new about all this, because we've quoted the Ginsburg standard after Justice Ginsburg said during her confirmation hearing, and it's probably been repeated several times, but I don't know that we can repeat it too many times, quote, "A judge sworn to decide impartiality can offer no forecasts, no hints for that would show not only disregard for the specifics of a particular case, it would display a disdain for the entire judicial process," end of quote. Senators know a nominee can't answer questions, but of course, those questions get answered anyway, and I would probably want to confess that 13 before you, I probably have asked some of those inappropriate questions. You were also asked many questions about how you would decide past Supreme Court cases, but you can't answer those either, as Justice Kagan told us, quote, "I've pretty consistently said that I don't want to grade or give a thumbs up or a thumbs down on particular Supreme Court cases," end of quote. At the time, the former chairman said, quote, "I certainly don't want you to have to lay out a test here in the abstract which might determine what your vote or your test would be in a case you have yet to see," end of quote. So you, the present nominee, deserve no less. and that applies to easy cases just as well as it might apply to hard cases. In any event, we don't need to dwell on hypotheticals. You have a 10-year record on the 10th Circuit. You've written over 770 opinions, or at least been involved with that many, and heard probably a little less than 3,000, but getting close to that number. So, without talking about hypotheticals, there's plenty that we can talk about. So I'm going to start by Thompson School District versus Luke P. Luke P. was an autistic student. His parents sued their local Colorado school district so that it would pay Luke's tuition at a private residential school. The statute at issue dealt with the Individuals with Disability Education Act. We call that IDEA for short. You held that the district didn't have to pay under this statute because all the experts who examined Luke found that he was progressing in his public school. Judge, where did you get that standard?
Mr. Chairman, the standard under IDEA, or as you said, the Individuals with Disabilities in Education Act, the standard that you've articulated is the standard set by the Supreme Court in a case called Rowley. And there are additional precedents in the 10th Circuit interpreting and developing that standard. And so in that case, Mr. Chairman, the panel was applying settled circuit law and Supreme Court law. Statute, as you know, balances two very important interests. The interests of children and their families with disability to ensure that the child receives appropriate education. On the other hand, it also balances the interests of school districts for whom these cases can be very expensive and challenging. And that balance is a policy judgment as to how that's made. That's made by this body. And then as interpreted by the Supreme Court in Rowley, those are the standards we apply, the policy choices of this Congress as interpreted by the United States Supreme Court.
And you didn't have any discretion to disregard that precedent of either the Supreme Court or the 10th Circuit?
No, Mr. Chairman.
And I think you had a Judge Briscoe, a Clinton appointee, was on the panel. And it's my understanding she joined your opinion in full. And so the Luke P. opinion was unanimous.
It was, Mr. Chairman.
Congress could, of course, as you said, amend IDEA, and states could create standards of their own, as Senator Tillis worked to do when he was in the North Carolina legislature. He's not here, but I think he would, that's my understanding, what he worked on.
That's my understanding too, Mr. Chairman, and of course I've had other cases involving IDEA where the parents and the child prevail based on the existing law. The School of the Deaf and Blind case, the Jefferson County case. So it just depends upon the facts and the law in each particular case.
Yeah. Well, I think you just pointed out my last point, that there's plenty of evidences that you rule as you see the law requires you to rule. Sometimes it comes out against the little guy and sometimes very much in favor of the little guy.
That's right, Mr. Chairman.
Okay. Because you take an oath to administer justice without respect to person and do equal right to both the poor and the rich. And it's your tenure on the 10th Circuit, I think, is a proud testament to the seriousness with which you understand the role of a judge, and you've ruled in favor of students bringing IDEA claims in other cases as well. I want to go on to something that Senator Klobuchar brought up, but probably something I was working on maybe before she even got to the United States Senate. And this is cameras in the courtroom. And I made a point when I appeared before the Judicial Council last week, and Chief Judge Justice Thomas introduced me. I said, remember, today I didn't bring up up about cameras in the courtroom. He says, we're getting off to a good start. Because obviously he does not agree with me on this point. She asked for your opinion on having cameras in the Supreme Court. Senator Klobuchar did. And you said that you hadn't given the subject a great deal of thought. I want you to know that I believe that public access to our court system is an important issue, and having cameras in the courtroom is one way to improve public access. Now, I know this isn't a very popular subject with some of the justices on the Supreme Court, as I just hinted. And in fact, as Senator Klobuchar mentioned yesterday, Justice Souter once famously quipped that the television cameras would have to, quote unquote, come roll over my dead body for that to happen. And he's not on the courts now, so that's one less person to have in opposition. I can respect that opinion, but quite frankly, it just happens to be wrong from my point of view. When Mr. Katyal introduced you on Monday, I was glad to hear him say that he wished the court would televise its proceedings so that all Americans could see what goes on there. That is a view shared by a number of my colleagues on this committee. We believe that allowing cameras in the federal courthouse would open the courts to the public and bring about better understanding of the court and its important work. You may be aware that for a number of years I've sponsored bills called Sunshine in the Courtroom Act, which give judges the discretion to allow media coverage of federal court proceedings. Given your discussion with Senator Klobuchar yesterday on the issues, I'm not going to ask for your opinion to have cameras in the courtroom, but I would very much appreciate this. If you would think about the issue, I would appreciate it if you keep an open mind as you move forward on this process. And I guess if I could ask you to have that open mind, that's all I'd ask you to do at this point.
You have it.
Yeah,
And
this is easy.
I'm sure I've gotten to know some of these guys pretty well over the last few weeks.
Okay.
Some nice folks.
I want to bring up the part that legislative history will bring up, and I think I'm going to refer to some cases. I don't know if it's the same cases I've read, but I know you have a different, maybe a little different point of view on legislative history, and I'd like to know what that is. But I also remember my first discussions with Justice Scalia, like when he came around to my office, as you came around to my office, I asked him about it, and he said it shouldn't play any role whatsoever. And I think I've seen him totally committed to that point of view during the 29 years that he was on the Supreme Court. He didn't lead me astray in my office, and he kept a pretty consistent point of view. So it deals with the weight that judges should give when interpreting statute. You've been a judge for over 10 years, so you've had time to think about the role of legislative history in cases that have come before you. In fact, there's one in particular that I'd like to discuss, one that Senator Feinstein talked about a little bit in her opening statements, U.S. versus Gamay Perez, I believe it's pronounced. The defendant in that case was appealing his conviction under a federal felony in possession statute, which provided that defendants must knowingly violate the law against felons possessing guns. The legal question before your court was whether the defendant must know both that he was a felon and that he was in possession of a firearm, or whether the government had to prove only that the defendant knew that he was in possession of a firearm. Now, at the defendant's original plea hearing, the trial judge told him, quote, "You will leave this courtroom not convicted of a felony and instead grant the privilege of a deferred judgment," end of quote. So there was a real question about whether the defendant actually knew that he was a felon. You upheld his conviction because the 10th Circuit precedent required you to do so. 10th Circuit precedent said that the word knowingly applied only to possessing a firearm, but not being a felon. Although you were required to follow precedent, and you did, you wrote a separate concurrence to highlight that the precedent should be revisited. You wrote, quote, "Our duty to follow precedent sometimes requires us to make mistakes. Unfortunately, this is that sort of case," end of quote. You went on to write, quote, "It makes no sense to read the word knowingly so modest that it might blush in the face of the very first element only to regain its composure and reappear at a second," end of quote, end of your quote. So you were somewhat critical of the 10th Circuit precedent because of its reliance on legislative history. You wrote that legislative history can be misleading because it is, quote, "stocked with ample artillery for everyone. The fight is hard fought. Each inch of the historical terrain is heavily contested, but in the end, almost no ground is taken by either side," end of quote. You touched on this a little bit yesterday, but I'd like to ask you when it's appropriate to look to legislative history to interpret statutes. Are there some circumstances when it's more appropriate than others? And what are the dangers? And I guess maybe 30 years ago, I told Scalia that history was very important. I'm not sure I agree with that today, knowing the importance of us writing clear statutes, but I thought we didn't always write very clear statutes, and I thought you ought to go back in and look what we think about it. But what are the circumstances when it's more important than others, and what are the dangers?
There's a lot to unpack there, Mr. Chairman. Let me begin by saying I respect all the work that this body does, and a good judge takes seriously everything you do and reads everything put before him or her. You don't close your mind to any argument. You put on the robe, you open your mind. But I think that case illustrates some issues along the lines of what you'd asked me to discuss. So the statute there says, simplifying, that it's a crime to knowingly be a felon in possession of a gun. And our precedent, on the basis of an interpretation about legislative history, and the legislative history was very long in that case, extremely long. The statute goes back, I think, to the 1940s and has been revised many, many times. So one can read a lot of history in that statute. And it can be argued both ways. There's good history, both sides cited us. On the basis of its reading of that history, our court took the view that the government need only prove that the defendant is a felon who's knowingly in possession of a gun. And that was the jury instruction given in that case. The defendant said, well, hold on a second. The word knowingly is here, knowingly a felon in possession. How does the word knowingly leap over the word felon and only touch down at the word in possession? Divide a bit of grammatical gravity, the defendant argued. And as a matter of plain meaning, I had to agree with him. I didn't understand how, just reading the words, the plain words on the statutory page, a reasonable person could understand that mens rea element, the knowingly, the mental element, to only apply to the second act in the statute, to the possession of the gun, as opposed to the knowing felon status. And the defendant had at least a colorable argument that he didn't know he was a felon in that case, because the sentencing judge told him he wasn't a felon. As you pointed out, Mr. Chairman, the sentencing judge, I think several times, as I recall the record, and it's been a while since I've looked at it, said more than once to him, if you complete your deferred sentence, you'll have no felony conviction on your record. So I thought this is a case where the government had to square its corners. And before you could put a man in prison, I think for 5 years in that case, may have been longer, felon possession statutes have rather long sentences attached to them, that the government should be forced to prove each and every element that the plain language of the statute imposed upon it. and that resort to legislative history to put a man in prison on the basis of legislative history rather than the plain language struck me as a due process, a fair notice problem to that individual. So that was why I wrote the concurrence. I followed our precedent. It's a precedent of the court. I have an obligation to do it. But I also felt I had an obligation to point out the mistake.
You may have just said this, but I want to emphasize, so I'd like to know what intersection you understand there is between notice of the law, legislative history, and original meaning of the legal text.
Yeah, and I did touch on it. I think notice is the key to the rule of law, that the people can understand what's expected of them, that the law is sufficiently clear that before they're put in prison for 5 or 10 or 20 years, and that's what federal sentencing statutes require of judges in many, many cases, that we're not putting them in prison on the basis of some secret law, some hidden, unexpressed intentions, or intentions that are very hard to find in the fine print of some book that's not available widely, but on the basis of what's in the statutory books that we're all charged with knowing.
Can I sum up what you just said? If I'm wrong, tell me, but you're basically saying the law means what it says it means. Is that right?
That's a good starting point, right? That the plain text of the statute is usually a pretty good starting point, and reading it as you'd expect a reasonable citizen to do so.
Yeah.
Not a pointy-headed judge.
I've only got 35 seconds left, so for the benefit of my members, I'm starting out on something before my time's up, so I don't know whether this is something I want you to comment on, but I want you to be very clear that sometimes cases dealing with the False Claims Act and qui tam come before the Supreme Court, and sometimes the Supreme Court gets us wrong from my point of view. There's lots of times, and Senator Leahy's been very good in helping me do this. We've had to rewrite the statute to get back to what I thought we made very clear in 1986, but according to the courts, we didn't make very clear. I co-authored this amendment to going way back to an 1860 law that the Congress obliterated because of World War II, because they didn't think defense contractors should be sued in those instances under qui tam. So we brought it back and even went beyond what it was in the 1860s to empower qui tam relators or whistleblowers to help the government identify and prosecute fraud on the taxpayers. The False Claims Act is the most effective antitrust tool that we have. And since the 1986 amendments that Congressman Berman, then a member of the House and I was a member of the Senate, got passed, the taxpayers have recovered more than $53 billion in public funds lost to fraud. And we had people in the Justice Department when we first passed this didn't like it, because it's if a relator came to them or a whistleblower came to them and they said that was like saying they weren't doing their job. We had a district judge in the late 80s, I think, told some prosecutor for the Justice Department that was trying to argue that a relator shouldn't have a certain amount of money. He said, do you realize you wouldn't even have a case if this whistleblower hadn't brought it to your attention? And I think we're over that now. But, you know, the Defense Department and the pharmaceuticals over the last 30 years have tried to gut this legislation. Even 4 years ago, the Chamber of Commerce wanted to do something to it that would have really done injustice to the good that it's not. So that's something, you know, that I think that it's working. We ought to keep it there. As you know, in most cases, the plaintiff must have suffered an injury to have Article 3 standing to come before the court. There is, however, an important Supreme Court case called Vermont Agency of Natural Resources, which established that key TAM relators have a constitutional standing under the False Claims Act to pursue claims for fraud against the United States. I don't know whether you're familiar with it. If you are, I guess I'm calling it to your attention so you can understand that that's pretty important from my point of view. You are familiar with it.
I am.
You nodded your head.
Mr. Chairman, I'm well familiar with your views on key TAM cases. I've had a couple in my circuit, and I know they've served.
Well, did you rule in my favor? No. You ruled in favor of somebody that was before you.
That one I have in mind, the little guy won that one, yes, okay. Mr. Chairman.
Okay. So I hope you know how important this rule has been for the protection of the Treasury against fraud. And I'm certainly very passionate about this issue. So I think if the false claims comes up, I hope sometime you'll remember, whether I'm alive or dead, that Senator Grassley is interested in this. Senator Feinstein.
Thank you. Thanks very much. Mr. Chairman, I'd like to put 3 letters of opposition in the record, if I may, with your concurrence. Thank you very much.
Sure. And is that all of them, or you got a couple others?
Yes, they're all here.
Okay. Without objection, whatever Senator Feinstein has that she wants in the record, without objection, it will be done.
Thanks very much. I'm not a lawyer, but as I read the case, this man was a felon in possession of a gun with a serial number struck off in concert with another man who had a weapon that I believe was used in the situation. So he was a felon with a gun, and his probation instructed him that he was not to carry that weapon. So I have very strong feelings about that, and I just wanted to say that. I don't think you have to respond, but what I'd really like to talk to you about—
Senator, may I?
Sure, absolutely.
I don't mean to eat up your time or anything, but this is exactly the sort of thing I think I've been trying to convey to members of the committee, which is it's my job to decide these cases without respect to persons. There is the little guy right there. He's a criminal defendant. It's unsympathetic. I understand everything you're saying about it. It's all true. The question is still, does the government have to prove what the law requires of the government, or anybody, the big guy? There's no bigger guy than the federal government.
I understand.
And so I'm just trying to follow the plain words of the law. Knowingly be a felon in possession. And the convicting judge told him that he wasn't a felon. And I followed precedent in that case, Senator. The man's in prison because of precedent. But I do wonder—
I accept that is your view,
okay.
And I'd like to move on.
Okay, of course.
It's not my view.
I understand.
He was a felon. So
yes, he was.
let me go on. I sent some documents not down to you, but over to you yesterday.
Yes.
And I'd like to ask you about one of them. And this is the one that has to do about torture. It's labeled at the bottom, DOJ NMG 0143890.
I know.
And I can send it down to you again if you want to.
No, I've got it right here.
You have notes in the
I've got it
slide.
right here, yes.
Okay. There's no date on the document, but the document talks about the McCain and Graham amendments to the Detainee Treatment Act, which was before Congress in November and December of '05. And it asks specific questions about the indictment of Jose Padilla, who was indicted on November 22nd, 2005. So the notes must have been on or after November 22nd, '05. Take a look at your handwritten notes on page 2. The document says, has the aggressive interrogation techniques employed by the administration yielded any valuable intelligence? Have they ever stopped a terrorist incident? Examples. Your handwritten note says yes. My question is, what information did you have that the Bush administration's aggressive interrogation techniques were effective?
And Senator, I'm working on 12 years of passage of time here, so my memory is what it is, and it's not great on this, but my recollection.
But you're very young.
Well,
Accept it.
I'll take it. Thank you. I'm not sure my wife entirely agrees with you anymore, Senator, but thank you. That's kind. My recollection of 12 years ago is that that was the position that the clients were telling us. I was a lawyer. My job was as an advocate, and we were dealing with the detainee litigation. That was my involvement.
You actually answered the question.
Yeah.
So
I
you
think-
had no personal information.
Oh, no.
That you took the position of your client.
Yes.
And that, because I know a lot about what happened.
I know you do.
That circles around in my brain a little bit, because it seems to me that people who advise have an obligation to find the truth in these situations. And when we learned about what happened on the Intelligence Committee, the Gang of Eight learned earlier, we learned much later, I think it was 2006. We saw, and when we looked into it, we really saw the horrendous nature of what went on. The absence of supervision, the absence of direction, the contracting out to people who, in my view, were not qualified to do what they did. And I think terrible things happened. It's a closed chapter, but it should never again happen. This is America, and it's not what we stand for. So let me move on to something that does trouble me about originalism, if I may. And let me read something. I have a constituent who happens to be the dean of a law school who sent me a question.
Uh-oh.
And I want to present it to you. And here it is. You are a self-professed originalist in your approach to constitutional interpretation. For example, you wrote, and I quote, "Judges should instead strive, if humanly and so imperfectly, to imply the law as it is, focusing backward, not forward, and looking to text, structure, and history to decide what a reasonable reader at the time of the events in question would have understood the law to be." Now, do you agree with Justice Scalia's statements that originalism means there is no protection for women or gays and lesbians under the Equal Protection Law because this was not the intent or understanding of those who drafted the 14th Amendment in 1868?
Senator, first of all, a good judge starts with precedent and doesn't reinvent the wheel. So to the extent there are decisions on those topics, and there are, a good judge respects precedent. That's the first point. Second point I'd make is it would be a mistake to suggest that originalism turns on the secret intentions of the drafters of the language of the law. The point of originalism, textualism, whatever label you want to put on it, what a good judge always strives to do, and I think we all do, is strive to understand what the words on the page mean, not import words that come from us, but apply what you, the people's representatives, the lawmakers, have done. And so when it comes to equal protection of the laws, for example, it matters not a whit that some of the drafters of the 14th Amendment were racists, because they were, or sexist, because they were. The law they drafted promises equal protection of the laws to all persons. That's what they wrote. And the original meaning of those words, John Marshall Harlan captured them in his Dissent in Plessy. And equal protection of the laws does not mean separate in advancing one particular race or gender It means equal. And as I said yesterday, I think that guarantee, equal protection of the law's guarantee, the 14th Amendment, that it took a civil war for this country to win, is maybe the most radical guarantee in all of the Constitution and it may be all of human history. It's a fantastic thing. And that's why it's chiseled in Vermont marble above the entrance to the Supreme Court of the United States.
Now, I understand that, but here's what is hard, and let me be very personal about it because this is important. I have sentenced women to state prison for committing abortion. I was a member when California had an indeterminate sentence law, actually the youngest in the country. And I know what life was like. You have 2 daughters.
I do.
I am one of 3 daughters, and I know what life was like. I have heard of young women killing themselves. I've heard of passing the plate in colleges so that a young woman could go to Tijuana to have an abortion. I read a letter from a woman who's going to be in the audience tomorrow of how trying to get pregnant, finding that the fetus was catastrophic and having just a terrible time. So the law has finally progressed that we now have the right to vote. That took a long time. We are still fighting for equal pay, for equal work, and it goes on and on. And as women take their place in the workplace, in society, we could have had a woman as president, perhaps. Life changes. And the originalism that the days when the Constitution was written project to me don't bring somebody forward, they bring them backward. In terms of rights that women did not have, they were not looked at as equal. As a matter of fact, we couldn't even get ratified a constitutional amendment, very simple, equality under the law should not be abridged on account of sex. That was the Equal Rights Amendment. And the time was extended from 3 years to give it more time, and they could not get the number of states to approve it. So if one looks at originalism in my context, which is real life, I want your 2 daughters to have every opportunity they possibly could have, be treated equal, be able to control their own bodies in concert with their religion, their doctor, whatever it may be, and not be conscribed to a lesser fate because the law is interpreted in a backward sense. Does that make sense to you?
Senator, I understand your concern and I share it. I come from a family of strong women. My 2 teenage daughters, you're right. I want every opportunity for them that a young man has. I have a strong wife. Anyone who knows her knows that. My mother.
But you are pivotal in this.
And Senator, I am daunted sitting here under the lights at the prospect of what's to come if I'm so fortunate to be confirmed. And I'm daunted by the job I currently hold. And I take that trust very seriously. And no one is looking to return us to horse and buggy days. We're trying to interpret the law faithfully, taking principles that are enduring in a Constitution that was meant to last ages, and apply it and interpret it to today's problems, And I think if you look at a number of cases where the court has applied what might be labeled by some as originalism, you will see, for example, in Kylo, the search of a home with a heat-seeking device. The court looked back to find out would that be considered an unreasonable search? That technology didn't exist, of course. But would something like that have been considered an unreasonable search at the time of the 4th Amendment's adoption? And found it's essentially equivalent to a peeping Tom. And of course that would have been considered an unreasonable search by the government. And so a heat-seeking device, thermal imaging, is also a search of a home. That's how we use neutral principles, the law, to apply it to current realities, not to drag us back to a past, but to move forward together as judges applying the law neutrally.
Here's the problem. I've been through this before. I've been through 6 hearings. I listened to Senator Specter when he was chairman of this committee tell the Chief Justice, well, you have described super precedent. We talked about precedent. And what's happened is every Republican appointed judge has gone back and is a no vote. So how does one look at you? And we've talked about precedent. For the life of me, I really don't know when you're there what you're going to do with it. And it's so, and as you say, this isn't text, this is real life. And young women take everything for granted today. And all of that could be struck out with one decision.
Senator, all I can do is, I can't promise you how I'd rule in a particular case. That would be deeply wrong to sit here at a confirmation table. And I think we agree on that it would be a violation of the independent judiciary for a nominee to a court to make a promise on any case in order to win confirmation.
No, I don't expect you to.
I know you don't, and I'm really grateful for that. I know you appreciate my position. All I can promise you is that I will exercise the care and consideration, due precedent, that a good judge is supposed to. And I've written a book on it. This is not something that is just words in a room. This is years of toil in putting together a mainstream consensus view on what precedent is and the law of it, with 12 judges appointed by presidents from both sides, with a forward by Justice Breyer. And I didn't expect anyone to ever read it. I think a few people have read it now, still not that many. But that's my life's work, that sort of thing. I care about the law. I care deeply about the law and an independent judiciary and following the rules of the law. And that's what commitment I can make to you. I can't promise you more, and I can't guarantee you any less.
Well, what worries me is you have been very much able to avoid any specificity like no one I have ever seen before. And maybe that's a virtue, I don't know. But for us on this side, knowing where you stand on major questions of the day is really important to a vote aye. And so that's why we press and press and press. It's very hard because you mentioned that the number of cases you sat on and the percent that was unanimous, I think was 97%, you said. And so we realize that these are few cases on which the distinction is made, and it's hard to make that distinction. So, you know, when one sees a lot in this country, and I just want to say this, for me, I sat on 5,000 cases. These were women convicted of felonies in the state of California. I did it for 6 years. And so I saw the inside of this whole issue. And that's one of the reasons why I feel so strongly, particularly, let me ask you another area, assisted suicide.
Sure.
You make the statement that there is no justification for having anything to do with the end of someone's life, encouraging the end of life. Well, California just passed an End-of-Life Options Act that takes a number, I think 3 doctors. I, in my life, have seen people die horrible deaths, family, of cancer, when there was no hope. And my father begging me, stop this, Diane, I'm dying. You know, my father was a professor of surgery. Now, trying to save him. So there are times you can't. And the suffering becomes so pronounced. I just went through this with a close friend, that this is real, and it's very hard. So tell us what your position is in the situation with California's End of Life Option Act, as well as what you have said on assisted suicide.
And Senator, this is something I can speak about because I've written about it, and I'm delighted to talk about my record. I wrote a book in my capacity as a commentator. It was my doctoral dissertation, essentially, before I became a judge. I'd have to tell you, as a judge, put that aside, and we talked about that. But I'll talk to you about what I wrote in the book, because I think that's fair. What I wrote in the book was, I agree with the Supreme Court in the Cruzan decision that refusing treatment, your father, we've all been through it with family. My heart goes out to you.
Yeah, well.
It does. And I've been there with my dad, okay? And others. And at some point, you want to be left alone. Enough with the poking and the prodding. I want to go home and die in my own bed in the arms of my family. And the Supreme Court recognized in Cruzan that that's a right in common law, to be free from assault and battery effectively, and assumed that there was a constitutional dimension to that. I agree.
Supposing you cannot handle the pain, and you know that it's irreconcilable.
And Senator, the position I took on the book on that was anything necessary to alleviate pain would be appropriate and acceptable, even if it caused death, not intentionally, but knowingly. Okay? I drew a line between intent and knowingly. Okay? And I've been there. I have been there.
Thank you. Thank you, Mr. Chairman. Sorry.
Senator, no apology.
Thank you.
Senator Hatch, because Senator Graham has to go to a hearing.
Thank you.
Or a committee meeting, has accommodated Senator Hatch.
Thank you so much.
Or Senator Graham. So go ahead, Senator Graham.
Thank you, Mr. Chairman. Let's see if I can sort of get my head around where we're at here. So I'm not so sure I've been playing the same game as everybody else. I might have to reevaluate what game I need to be playing in the future. It's important to know where you stand before I can vote yes. I think that's true for a Republican nominee, but not so much for a Democrat. Let me tell you what Senator Leahy said. I certainly don't want you to have to lay out a test here in the abstract, which might determine what your vote or your test would be in a case you have yet to see that may well come before the Supreme Court. Now, that's the standard when there's a Democratic nominee. And when there's a Republican nominee, you've got to tell these senators that you won't get in the way of their agenda. I'm not asking you to tell me whether or not you agree with my agenda. I'm asking you whether or not you will fairly hear the cases before you, because to do anything else would be unfair to you. The life issue is very real. There are a lot of Americans who believe that life begins at conception. There are a lot of Americans who believe that Roe v. Wade was a grab of power from legislative people, but it is the law of the land. It will be given due weight if somebody challenges it. Do you agree with me it is the law of the land that in late-term abortions, they have been limited through congressional action and approved by the Supreme Court?
In certain circumstances, yes.
In certain circumstances, the Congress overwhelmingly voted to limit abortions in the last trimester, and the Supreme Court said in those circumstances, you have the authority to do that. Is that the state of the law?
That's part of the state of the law, Senator.
Okay. And I would imagine this issue will be revisited as long as people have differences. There will be a lot of issues coming before the court because Americans don't agree on some of the more emotional topics, like when life begins and what's the role of the legislative body, what's the role of the court, when do you have a soul if you have one, and what's the right to be conferred by unelected judges versus people who have to answer to the public. So all I'm saying, if we're going to vote against a nominee because they won't tell us things that we want to hear about issues important to us, then the whole nominating process has become a joke. And what has happened over time is that somehow, some way, we've gone from Scalia, the originalist, getting 98 votes, Ginsburg, the bastion of liberalism on the court, well qualified, getting 96 votes. What's happened? Did the Constitution change? I don't think so. I think politics has changed. I think it's changed in a fashion that we should all be ashamed of as senators. And I think we're doing great damage to the judiciary by politicizing every judicial nomination. If you don't agree with my basis view of the world, I cannot vote for you. This is what Greg Craig, the former White House counsel in the Obama administration, said about Elena Kagan. She's a progressive in the mold of Obama himself. So Reince Priebus said that Trump picked a good guy. Well, Craig Craig, the former White House counsel, said that Obama picked in Elena Kagan a progressive in the mold of Obama himself. I did not vote for President Obama, but he won in spite of my opposition. I do believe as President of the United States, he had a right to pick somebody from the progressive wing of the law. I expected him to do so, and he did. Twice. I knew full well what I was getting. And I hope you understand that you're getting one of the most qualified conservative judges in the country. Senator Feinstein said her goal was to find out if you're a reasonable mainstream conservative. I would tell you, Senator Feinstein, without any hesitation, this man is as mainstream as you will get. If you don't believe me, listen to the people who know him the best. 2,700 cases and being reversed once. The bottom line here is we're taking the nomination process to a place it was never intended to go by the framers of the Constitution. And Alexander Hamilton would be rolling over in his grave to believe that the United States Senate has now gotten to the level of where I can't vote for you if you won't tell me about cases important to me and you don't share my philosophy. That means advise and consent is not really advise and consent. It means that we are the president and we're the judge. And if you wouldn't rule like us, you can't be on the court. And if you come from a philosophy that we reject as a party, then you can't be a judge. That would be bad for the country. Now, let's talk a little bit about Griswold. You said that Griswold was a case decided by the Supreme Court that does what?
Senator, it guarantees married couples the privacy in their own home to use contraceptives.
Is it a longstanding precedent of the Supreme Court?
It is, Senator.
What weight would you give that?
Well, Senator, under the law of precedent, you look at the age. This one's over 50 years. You look at the reliance interests, which are obvious and substantial. You look at whether it's been reaffirmed, which it has many times. And Senator, as I said yesterday, I just cannot imagine a state attempting to pass a law like that.
Well, let's say they did.
And I can't imagine the Supreme Court of the United States taking that claim seriously.
Let's say they did, and I'm with you on both. Would you listen to the people who made the argument, to make the argument?
Senator, you listen to every person who comes to court.
So to overturn Griswold, you got to get a case in controversy, right?
Right.
That means somebody somewhere has got to convince, I don't know, some state or somebody somewhere to outlaw contraception in the marital relationship. That would be a case in controversy.
Well, you'd have to have a state that pass a law like that.
Or what about a city council?
Or whatever, and then you have to have somebody try and enforce it.
Right. Then it would maybe get to you. And if that day ever come, you would listen to what the other side had to say, then you would decide. Is that fair enough?
You'd apply the precedent of the United States Supreme Court. And if they were trying to overturn the precedent, you go through the factors and you consider them. And
So you're not here to tell us what you like or don't like in the law. You're telling us about the process of how the law works.
That's right, Senator.
And you're here as a human being, can't imagine some legislative body, particularly at state level, outlawing contraception. You just don't see that as a real threat right now.
I don't see it as a real threat today,
Okay.
Senator.
Originalism. Are you an originalist?
Senator, as we spoke of yesterday, I'm happy to be called that. I do worry about the use of labels in our civic discussion to sometimes ignore the underlying ideas, as if originalism belonged to a party. It doesn't. As if it belonged to an ideological wing. It doesn't.
Well, here's what I would say about originalism. Whether you like it or not, is it bound by the law?
That, of course it is. It's the whole point of how you interpret the law.
Now, to those who believe that the Constitution is a living, breathing document that can speak to you and nobody else, that bothers me. But there are people on the Supreme Court who have the view that the Constitution is a living, breathing document related to the times in which we live in. That seems to open the door that I can get the outcomes I want, not so much bound by the words or the history. The bottom line is there are different ways of looking at the role of being a judge. Do you believe that your way of looking at being a judge has stood the test of time?
I do.
Do you believe over the last 10 years your way of looking at being a judge has received respect from people who disagree with you?
I think you're going to hear from some of them tomorrow.
Do you believe that the American Bar Association has looked at your way of being a judge and found you well qualified?
I'm very honored by their assessment.
You've decided over 2,700 cases, is that right?
That's right.
Been overturned once, maybe?
Maybe.
Okay. I'm going to say once,
Well,
and you're just going to have to live with it
well,
and accept it.
may,
The bottom line is,
Maybe.
let's say it's once. I would say that the way you judge has been viewed by people above you as being acceptable almost all the time but once. Now, to my friends on the other side, what more can you ask for? What are you looking for? Are you looking for somebody that will make your political life easy? Well, he's not the guy. Because he's not going to make your political life easy, because he was appointed by the guy that you were all against, and I didn't vote for. I haven't voted for a president who won in 12 years. So I'm probably not the one to give you legal advice, political advice. But I have voted for nominees of those who did win in the time that I've been here. I intend to vote for you for the same reasons that are articulated for Sotomayor and Kagan in terms of your qualifications. I intend to vote for you because I think you represent a conservative view of how to be a judge. I'm excited about that. I think President Trump, with all of his problems and all of his mistakes, chose wisely when it came to this man. I want to congratulate the president. And I want to say this, that when you rejected some of the statements that President Trump made toward judges as being, what were your words?
Senator, I spoke of when anyone,
Which would include President Trump.
anyone
Okay.
criticizes the honesty, the integrity, the decency of federal judges and what they do, or attacks their motives and how they come about arriving at their decisions. I know those people. I know how hard they work and how decent they are. I find that disheartening and demoralizing. That's what I have said. I'm not saying we're immune from attack from decisions. I'm not saying that we shouldn't have thick skin. My hide's pretty thick. And I know that the hides of federal judges have to be.
Well, I just want to associate myself with what you said about what President Trump said, that I thought it was really out of bounds. You're the most powerful man in the world, and judges work in quiet, dark corners. They have no political machine. They have no PAC. They can't go out and do news conferences. Of the three branches of the government, they're the most vulnerable. So I stand firmly with you and firmly with anybody, and my friends on the other side say that President Trump was really out of bounds. But here's what I wish some of y'all would do. Here's what Nancy Pelosi said. If you breathe air, drink water, eat food, take medicine, or in any other way interact with the courts, this is a very bad decision. That means picking you. I haven't heard one person on that side say, that is out of bounds. That is political garbage. To my good friend Ron Wyden, no senator who believes that individual rights are reserved to the people and not the government can support this nomination. Elizabeth Warren, let's not mince words. The nomination of Judge Gorsuch is a huge gift to the giant corporations and wealthy individuals who have stolen a Supreme Court seat in order to make sure that the justice system works for them. It's okay to criticize Trump, but apparently it's okay for you to slander this man, and none of you say a damn thing about it. I don't think it's okay. I don't like what's going on here. I don't like where the Senate's heading, but there's nothing I can do about it other than be myself. So, Judge, I just want to say, I think you're qualified. I think the answers that you can't give us come from the fact that you understand that if you gave those answers, you would compromise your ability to fairly decide cases that may become before you in the future. And that when a Democrat says that, they're just being a good judge. When you say that, oh, I can't vote for you. What a double standard. Thank you.
Mr. Chairman, while the senator from South Carolina is still in the room, he began his statement quoting me and saying, of course, and went on to say the president should be able to show his own philosophy, his nominations, and he pointed out that President Obama, as he said, nominated 2 Supreme Court justices. I think the record should show President Obama nominated 3 Supreme Court justices, one of whom was Merrick Garland, a person whose philosophy has been praised by both Republicans and Democrats, and it was the Republican Party that ignored the Constitution, did not allow him to have a vote, did not allow him to come before this body, did not uphold their advice and consent oath and their advice and consent. So I just wanted the record corrected. It wasn't 2 nominees, it was 3. The third one was not heard because for the first time in the history of the United States, the Senate refused to hold a hearing, refused to have a vote. Now, Senator Feinstein talked about the dark days before Roe versus Wade. I have some experience with that. We have 2 cases in Vermont, Leahy versus Beecham and Leahy versus Bartlett. I'll tell you very briefly about it. Leahy versus Beecham was a case that, in fact, I brought a declaratory judgment before Roe versus Wade, before the Vermont Supreme Court. I organized that case so that the Vermont Supreme Court, a very conservative court, could rule on the constitutionality of our anti-abortion statute in Vermont. They came out with a decision, basically what Roe versus Wade did. This conservative 5-member Vermont Supreme Court in Leahy versus Beecham. Leahy versus Bartlett was a case where I prosecuted somebody procuring abortions. And these are the dark days that I don't want to go back to. I got a call from the police at 3 o'clock in the morning. I was state's attorney at the time. I went to the emergency room at our local hospital. A young co-ed nearly died from bleeding from a botched abortion. At that time, it was illegal. We found out the person who had procured them. He had done this with a number of people. He would then blackmail them for either sex or money. And when I brought it to trial, we found the person doing the abortion was from Montreal. They said they'd go to trial figuring she'd never appear to for the case. She was there. 2 Royal Canadian Mounties escort her. And I pointed out to the defense attorney, the evidence would show she was trained to do these abortions, working for the SS at Auschwitz, so she could abort the women prisoners that they had impregnated, so that they could keep on using this women that way before they put them in the gas chambers. He looked at the names of the people who would be the potential jurors. They sought a plea. Now, on another, so I applaud the senior senator from California for raising the issue she did. Now, yesterday, I asked about your connections to billionaire super donor Philip Anschutz. In his role, his very extensive role in lobbying the White House to get you on the 10th Circuit. And once on the court, you said you recused yourself from cases involving him, and I commend you for that. You did the right thing. But you wrote in your Senate questionnaire that you currently follow a recusal standard broader than what is required by the Supreme Court. And if confirmed, you'd follow the weaker Supreme Court standard. Does that mean, if confirmed, you would no longer recuse yourself from cases involving Mr. Anschutz?
Senator, what it means is I will, if I'm fortunate enough to be confirmed, go through the same process I did when I became a judge on the 10th Circuit, and which I committed to do at that time, which was look at the applicable law, look at the facts. I had a law clerk. I don't know if he's somewhere around here.
Well, no, but let me get back to this. You found the facts were such that you recused yourself.
Yes.
With Mr. Anschutz when you were on the
Yes.
Court of Appeals.
Yes.
If he had a case before the U.S. Supreme Court, would not the facts be the same?
He is a former client, and I treated him as I treated my former clients, large and small. And Senator, I'd have to look at the recusal standards that are applicable to Supreme Court justices.
Well, the federal recusal standards apply to both Supreme Court justices and other judges.
Yeah.
But the only difference is, of course, Supreme Court, whether they recuse themselves or not, that's not reviewable. But would you, again, you found enough reason to recuse yourself on the circuit, and I applaud you for that. Would not those same reasons apply to the Supreme Court?
And Senator, I just have to study the law and the practice of the court, just as I did when I came on the 10th Circuit. And I commit to you the same process and the same integrity of the process. You look at the law, you look at the practice of your colleagues, you consult with your colleagues. That's what I did. I had a law clerk prepare an extensive memorandum for me in which he analyzed all of the relevant precedents, the practices of my colleagues,
Well,
and
I would note that
the facts.
The federal recusal standard, as far as studying the law, it's the same law for the Court of Appeals and the Supreme Court, with one exception. The Supreme Court's not reviewable. Now, I asked you yesterday whether there was any circumstance in which the president has the power to authorize torture or surveillance in violation of laws passed by Congress. You answered, I thought, correctly. No man is above the law. Now, I'm sure President Bush and his lawyers believed he was operating within the law when he authorized torture and warrantless surveillance, but they still thought they could violate a statute if they're exercising their Article II power. Is there any circumstance where a president could ignore a statute passed by Congress, signed into law, and still authorize torture or warrantless surveillance? If you had a statute against torture and warrantless surveillance, is there any circumstance in which a president could ignore that statute?
Well, Senator, I don't want to deal with a case that might come before me, and those are the sorts of things that could come before me. But I can speak generally, and I'm happy to.
Go ahead.
Presidents make all sorts of arguments about inherent authority. They do. And that's why we have courts to decide. Presidents of both parties have made arguments, for instance, about the War Powers Act. Both parties. And the Congress has taken a different position on that matter, for example, with both parties. And the fact is we have courts to decide these cases for a reason. to resolve these disputes. And I would approach it as a judge through the lens of the Youngstown analysis.
Have you
And
thought of a
Justice
case
Gadsden.
where a court has said a president could ignore a law that was on the books?
Senator, sitting
Can you
here,
think of one offhand?
I can't think of one offhand,
Thank you.
Senator.
Neither can I.
Yeah.
Now, the architect of President Trump's Muslim ban has declared that there's no such thing as judicial supremacy. And the powers of the president to protect our country, quote, are very substantial and will not be questioned. It was felt that he was signaling that the president could ignore judicial orders. Any president, do they have to comply with a court order? Assuming, I mean, obviously they can appeal one, but assuming it's been upheld, do they have to apply, do they have to comply with it?
That's the rule of law in this country, Senator Leahy. And presidents for a long time have said all sorts of things like that. President Jefferson said things like that.
Well, we're not,
President
he
Jeff-
was slightly before my time.
But presidents say these things, right? Congress says things, and then judges decide. And that's the way our system works. And Senator, all I can commit to you again is I'm a judge now. I take that seriously. And you better believe I expect judicial decrees to be obeyed. As I said yesterday, a wise old judge you're going to hear from tomorrow, one of my heroes, says the real test of the rule of law is where a government can lose in its own courts and accept those judgments.
I believe in the rule of law, too, and that's why I've stayed on this committee for decades.
I know.
When I took my oath before the Vermont Supreme Court, when I was sworn into the bar, I took that very seriously. I did with our Second Circuit Court of Appeals and our federal courts, and when I was sworn into the U.S. Supreme Court bar, I took that very seriously. I believe that ultimately we are a country of laws, and we should follow them. Now, speaking of which, yesterday we discussed the relevance of what our framers meant in the Constitution. And many feel they want to prevent a president from being corrupted by foreign governments. Obviously, I'm referring to the Emoluments Clause. What is the purpose of the Emolument Clause?
The Emoluments Clause, Senator, is not a clause that had attracted a lot of attention until recently.
Well, Governor Randolph of the 1787 Constitutional Convention pointed it out. I mean, you want to go back to Jefferson, I'll go back to Randolph.
Hey, I'm with you. Among other things, it prohibits members of the government of this country from taking emoluments, gifts from foreign agents. And the question is, what exactly does that mean? That is a subject on which there is ongoing litigation right now, Senator, I believe, certainly threatened litigation, impending litigation, and I have to be very careful about expressing any views.
Well, what Randolph said, it was done in order to exclude corruption and foreign influence, to prohibit anyone in office from receiving or holding any emoluments in foreign states. Now, you're hesitant to discuss it. You wouldn't be hesitant to discuss the Fourth Amendment or the Fifth Amendment, would you?
Well, I'm hesitant to discuss any part of the Constitution to the extent we're talking about a case that's likely to come before a court, pending or impending. And I do think that the Emoluments Clause has sat in a rather dusty corner for a long time until recent headlines, and I know that there are cases that are at least impending in that area. I'd be happy to try and talk about things that aren't likely to come before me, but
Well,
I
let
can't.
me ask you this. Then what does the Constitution say a president must do if he or she receives a foreign emolument?
Well, Senator, that's a good question. I don't believe it's been fully resolved.
Well, I thought it's kind of easy. The clause prohibits receipt of any emolument without the consent of the Congress.
Right.
Now, you're a judge. I'm, as I said yesterday, a lawyer from a small town in Vermont. But if it says they cannot receive any emolument without the consent of the Congress, isn't the answer pretty simple? What a president must do if he or she receives a foreign emolument, they have to get the consent of the Congress.
Sure, I thought you were asking what would be the remedy if they violated. And
No,
I
I'm
don't-
asking what they have to do.
No, you're absolutely correct, of course, Senator.
I appreciate that.
Well, no, I think you've read the clip.
Because I understand your concern, and I appreciate it as a judge
I know you do.
answering questions about any pending litigation. But you have been very hesitant to even talk about various Supreme Court precedents. I know that Chief Justice Roberts, when he was before us, he said he agreed with Griswold and Brown. Justice Alito said he agreed with Hamdi and Eisenstadt. So we've had justices nominated by Republican presidents who have been willing to discuss past precedent. I was just kind of hoping you'd be as transparent as these prior nominees were. During the campaign, President Trump promised to appoint judges very much in the mode of Justice Scalia. Now, he had every right to say what he wanted. He could have picked anybody. The vice president said you two are cut from the same cloth. But Justice Scalia is a friend of mine, is an intelligent, influential jurist. I voted for it, in case people wonder, and not just because we both have Italian ancestry, but as an interpretation of the protections afforded by the Constitution left our most vulnerable communities out. Do you agree with Justice Scalia's characterization of the Voting Rights Act as a perpetuation of racial entitlement?
Senator, the Voting Rights Act was passed by this body during the Civil Rights era in order to protect the civil rights.
Well, it was also updated just a few years ago during President George W. Bush's tenure.
2006, it was reauthorized with the support of the president. That's right. That is true. And it is designed to protect the civil rights of Americans.
But do you agree with Justice Scalia's characterization of it as a perpetuation of racial entitlement?
Senator, I don't speak for Justice Scalia. I speak for myself.
Okay, accept that. Others who, there's a lot of people who in the administration have described who you are. One of the reasons we have these hearings is so the American people and this committee can determine better who you are. And that's why I made it very clear, I'll be here at the hearing and make that determination. Because I was concerned, I knew that Steve Bannon was a strong advocate for your selection. And with all due regard to Mr. Bannon, he's well known for giving a platform to extremists and misogynists and racists. At the CPAC conference a few weeks ago, both Mr. Bannon and Reince Priebus praised your nomination, and I'd ask consent that a report of that be included in the record.
Without objection, your article will be entered.
And Mr. Priebus said you have the vision of Donald Trump, and by nominating you, Donald Trump was talking about a change of potentially 40 years of law. Suggesting you're coming there as a Trojan horse. What vision do you share with President Trump?
Senator, I mean no disrespect to any other person in saying they don't speak for me, and I don't speak for them. You know, I have great admiration for Justice Scalia, as we've talked about. I have admiration for every member of this committee, for the President of the United States, for the Vice President of the United States. But respectfully, none of you speaks for me. I speak for me.
Okay.
I am a judge. I am independent. I make up my own mind.
Well, the reason I asked, Mr. Bannon and Mr. Priebus and the President had closed-door interviews with you. And in these things, including this material I've just put in the record, they promised their donors a nominee that would bring a pro-corporate, socially conservative agenda to the court. Are you saying they're speaking for themselves, not for you?
I am.
Thank you. In your view, in the Constitution, it speaks about high crimes and misdemeanors. What kind of conduct does that include?
Well, Senator,
We've talked about the founders. They put that in, so.
I think, you know, classically, we've talked about felonies. It has been typically what this body has impeached individuals for. There have been a variety of cases involving, sadly, federal judges, as well as presidents, as well as justice attempt. And usually it's been more along the high crimes rather than the misdemeanors.
I would assume that you would not think of a misdemeanor in the sense that we have like traffic violations, going through a stop sign or something like that. That's a misdemeanor. Would you accept that that's probably not what is meant in the high crimes and misdemeanors?
I would not want to issue an opinion on that without the full judicial process, Senator.
All righty.
I don't know. I know misdemeanors in 1789 looked a lot different than misdemeanors today. We have a lot more criminal law today and a lot more misdemeanors today than we did back then. I can say that.
I'm going to start driving more carefully. Thank you, Mr. Chairman. Senator Hatch.
Judge, I've only been around here 40 years, and I've seen an awful lot of great people in the law come before this committee. And I haven't seen anybody any better than you.
Can't hear him.
I'm very proud of.
Can you
Go ahead.
talk louder?
You have to, the mic is not carrying you. Or,
I'm very proud of you and the service that you're giving to our country. There's no question that any fair observer would say how lucky we are to have you nominated by whoever to be a justice on the Supreme Court of the United States of America. I held the highest rating an attorney could have when I was a partner in a Pittsburgh law firm. In Utah, I held the Martindale-Hubbell AV rating. These are ratings, as you know, given by your peers without your knowledge. And I have to say that I've been around here 40 years, and I've seen all kinds of judges come before this committee. And there have been a number of great ones. And you, sir, are one of the great ones. And I'm proud of you. But I knew that before you came here to testify. But now that you're testifying, it even reinforces that opinion in my mind. And why anybody in this body would vote against you, I'll never understand. Admittedly, you're of a different political persuasion, perhaps, than some of my friends on the other side. But I've supported people who are totally different from my political beliefs. And all I can say is that, you know, and I've refused to support some people too, but my gosh, you know, let me just go into this. I'm troubled by the suggestion that skepticism of Chevron, the Chevron case, somehow means that one is somehow reflexively opposed to regulation. In my mind, such a charge is completely unfounded. After all, it's important to remember that Chevron deference first flourished as a reaction against liberal judges overturning the articles of the actions of the Reagan administration. And after many of my colleagues on the other side of the aisle have now suddenly rediscovered the importance of the Constitution's limits on executive power, something they were conspicuously silent about when President Obama was in office, but are now quite enthusiastic about that now that a Republican is in the White House. And I find it surprising that they don't appreciate how Chevron impedes an independent judiciary's ability to hold the executive branch accountable to the law. Now, Judge Gorsuch, do you think your writings reflect a knee-jerk attitude against common sense regulations?
No, Senator.
I don't either, even if you didn't like those regulations. Is that fair?
Senator, I've enforced all manner of regulation that's lawful without respect to my personal point of view.
And sometimes you didn't like some of them.
Senator, whether I did or didn't is not material.
Well, I kind of would like to hear, though, even so. That's okay. In addressing the Chevron issue, many are invoking the importance of relying on scientific expertise. But despite how some are mischaracterizing the issue, Chevron deference isn't the same thing as respecting the judgments of experts on technical matters, but rather about how to handle questions of law, questions in which judges themselves are experts. Nor does the issue of judicial deference call into question how much authority Congress can or should give agencies and their experts to write regulations. Now, Judge Gorsuch, would you mind explaining the difference between all of these issues for those who may not be experts in administrative law?
I'd be happy to, Senator.
Okay.
Section 706 of the Administrative Procedures Act says basically two things, and I'm paraphrasing. It says that courts are supposed to defer to the factual findings of agencies. So to the extent you're talking about expert biologists, chemists, whatever manner of regulatory expertise we're talking about there, the courts are to defer to that and to take that seriously. And we do, just as we would, say, the factual finding of a jury or a district court judge that comes to us with a presumption of correctness, clear error standard of review, very hard to meet. Section 706, however, also goes on to say that when it comes to questions of law, the courts are to interpret the law. Despite that command from this body, the courts have created a doctrine that says that if there's any ambiguity in the law, the agency gets to make the decision about what the law means. And I have questions about that doctrine. I've raised questions about whether that's compatible with the plain language of Section 706 and the instruction of this body. And I've raised some questions that arise in a case that I actually had to deal with, and how it would impact people, real people, if agencies can change the meaning of the law back and forth every 4 years, depending upon the outcome of an election, for example. What happens when some individual, I'm not worried about large corporations here, honestly, Senator Hatch. They've got armies of lawyers, lobbyists. They can predict which way the wind's drifting in the agency. Sometimes they can capture the agency. I'm worried about the ordinary American, and sometimes even the non-American. The case happened to involve an undocumented immigrant. That's the case I actually dealt with. And there he faced two competing statutes. One said he could rely on and seek permission to remain in the country from the Attorney General, and get immediate discretionary relief. The other statute said he had to wait out of the country 10 years. Our court interpreted the law, as Section 706 says we're supposed to, and said the first statute controls, because there was an apparent conflict between the two, and said he could rely on the opportunity to seek immediate discretionary relief. He did, in reliance on that judicial precedent. Then the agency comes in years later and says, we're wrong. Chevron, sprinkle some Chevron on it. We have to overturn our decision, and he has to leave the country and wait not just 10 years now, but 13 or 14 or whatever it was. And to me, that raises questions not only about the consistency with Section 706 and the instructions that Congress has given us, but due process and fair notice. If the law can change so easily, not through bicameralism and presentment to the president, bicameralism in this body, passage of both houses, presentment to the president, the order specified for lawmaking in the Constitution. If the law can change so easily as that, where's the due process to the individual, the person who doesn't have an army of lawyers? How is he supposed to figure that out? What about the equal protection problems when you allow an agency to pick and choose unfavored targets for changes in law? They don't have to go through bicameralism and presentment. They can pick their targets with more or less impunity. The least amongst us, the most vulnerable, the little guy, if you will, the person without the lobbyists. And then what about the separation of powers? I thought the judges were supposed to say what the law is. I thought that's what Justice Marshall said. And I thought the point of having judges decide the law is because you wanted someone who's neutral and independent to say what the law means, someone who doesn't have a dog in the hunt. So those were the questions I raised in that case. I did it as a circuit judge because part of my job as a circuit judge is to identify problems that I see from my bosses. So, Senator Hatch, that's a long-winded answer, and I'm sorry for it, but I hope it's helpful.
Well, I liked it. I liked it. I think, it, again, perfect illustration of why you should be on the United States Supreme Court. And while they may sound like legal technicalities, I think it's incredibly important that we distinguish questions of law, questions of fact, and questions of the wisdom and constitutionality of agency authority, which I think are being confused and conflated to suggest that reining in Chevron somehow represents an attack on the role of experts in developing sensible safeguards that keep us healthy and safe. So I appreciate your comments. In previous exchanges, a number of my colleagues have brought up your work on some of the very difficult issues that you have dealt with while you were a lawyer in the Justice Department. And while I appreciated your answer, I wondered if I could describe the responsibilities, if you could describe the responsibilities of a government lawyer just a bit more. In particular, I'd like to hear you briefly spell out your understanding of the difference between policymaker and advocate, as well as the distinction between how a lawyer might be called upon to give a different type of evaluation of the law as an executive branch lawyer than as a judge or justice. I just don't want you to get unfairly tagged with the legal and policy views of an administration that you personally might not share. So I'd like you to take some time and explain that.
Senator, as lawyers, we play different roles in different places in our lives, and depending upon who our client is at the time. As a private lawyer, I represented plaintiffs and I represented defendants. I represented large corporations. I represented individuals in class actions and pension funds, public employee pension funds, CalPERS, for example. I represented hospitals, doctors, victims, defendants. So where you stand as a lawyer changes. You're someone's voice. You're your client's voice. So that's in private practice, what a lawyer does, consistent with the rules of ethics and the law of the land as best they can. And often, those are hard things, because your client's interests always butt up against another person's. And sometimes I ask whether our rules of ethics are all that great. One of our rules of ethics, when talking about the zeal a lawyer should exhibit, says that a lawyer doesn't have to engage in offensive tactics. Well, how's that for a professional promise? We don't have to engage in offensive tactics. I don't know. Only a lawyer could love that. At any rate, moving to government practice, there are policymakers who are the clients. The President of the United States, the Attorney General, the cabinet officials, they're the policymakers. The role I served in was in a litigation capacity, supervising cases and controversies, civil lawsuits involving the United States as my client. I was in the role of an advocate in those cases. As a judge, you put that aside. You put aside all the stuff you did as plaintiff or defendant in private practice, all the stuff you did as a government lawyer, and you only have one client now, the law. You wake up every day and you just try and get it right as best you can. And Justice Jackson is who comes to mind here to me. He was one of the finest and fiercest advocates of his day, and one of the fiercest advocates of executive power when he was Attorney General of the United States during the New Deal for Franklin Delano Roosevelt. When he became a judge, he also became one of the fiercest critics of executive power as a judge, because he knew the difference in roles that we serve. And he said a robe changes a man, or should. And I believe that, and I've seen it. I've seen so many fine lawyers go on to be very fine judges and put aside their personal points of view or their clients' perspectives or which side of the V they served on or what sort of client they served and become neutral, fair judges. At least that's what I've aspired to be for the last 10 years.
Well, and I think you've accomplished that, too. Judge, yesterday, Senator Sass spoke to you about the need to teach civics to our fellow citizens, and especially to the younger generation. And I hope that this hearing is contributing to that, because perhaps the most prominent theme this week has been the separation of powers. Now, you said yesterday, and I agree, that the separation of powers is critically important, but seems to have gotten lost today. Now, judges do not exist and work in a vacuum doing whatever they want to do. They exist and work as part of a system of government and therefore must do what they are supposed to do. The role of judges in that system is by design, and that design has a purpose, described in the Constitution's preamble as including securing the blessings of liberty. Our liberty requires that each separated branch of government stick to its job. That's why I think one of the most important things you said yesterday was this, quote, "It's not my job to do your job," unquote. I thought that was pretty neat for you to say that. So let me ask you to expand on that simple statement, if you would.
Senator, we all have roles to play. When we choose to take up a role in our government, we all have a particular place in it, and we have to respect the boundaries of it. And it is my job to respect, in part, the boundaries of this branch and not engage in the temptation to legislate through the cloak of a judicial robe. Judges would make very poor legislators.
Well, sometimes legislators make very poor legislators, too. I've seen a few.
I respectfully disagree, Senator. I have great respect for this body. And I know.
I didn't say all.
I know in our civic culture today that there's a great pessimism about our government. I don't share that. I think this body still works. And I think it's important and vital that it work, because it's the people's voice. It's the people's representatives. It's where lawmaking is supposed to occur. And for you to do your job, it's important that I don't do your job. It's important that I do my job and let you do yours. If judges became legislators, we'd be bad at it, and we'd absolve you from your responsibilities. You could wash your hands of it. Sounds like some might want to do that. I don't know. You're smiling. But respectfully, I'm poorly equipped. I'm not a representative of the people. I'm not answerable to the people, and I don't have the expertise of your wonderful staffs that are sitting behind you. My job is to decide cases, and I'm okay at that on a good day, right? I'm never going to be good at your job, and I need to respect that. And it's also very important for legislators to respect that we do what we do, and that we don't run campaigns, and we don't make promises about how we rule in cases and controversies that come before us. That's part of the mutual respect for the separation of powers.
Well, you've cited Justice Robert Jackson several times. In fact, he once occupied the seat to which you have been nominated. In 1953, he lamented what he considered a widely held belief that the Supreme Court, quote, no longer respects impersonal rules of law, but is guided by personal impressions, which from time to time may be shared by a majority of justices, unquote. One recent poll showed that 3/4 of Americans believe that the Supreme Court decisions are influenced by the justices' personal political views. Isn't this what we're really talking about? And what the approach called originalism is really all about? Shouldn't judges base their decisions on impersonal rules of law rather than their own personal impressions?
And Senator, I'm here to testify to you that that is not how I see our judicial system operate.
Yeah.
We resolve hundreds of thousands of cases every year in the federal system, almost all of them, as I say in the 10th Circuit, for example, unanimously. It's a remarkable thing that even when we get to the Court of Appeals, only 5% of all cases get so far as my court. And even then, of those over the last 10 years, we've been unanimous 97% of the time in the cases I've participated in. That's a wonder. That's an amazing accomplishment. That's the rule of law in this country. And too few people know how it actually works. And if they did, they'd be heartened.
Thank you, Judge. I appreciate your comments.
Just as soon as I make 4 announcements, we're going to take a 5-minute break. First of all, I want to enter into the record a Washington Post op-ed by 2 former chief judges of the 10th Circuit, Judges Taha and Henry, entitled "Gorsuch is the kind of judge our framers envisioned." Without objection, that will be entered in the record. Secondly, my plan is to, in consultation with Senator Feinstein, to take a break around 12:30. Whoever's just ready to start about that time or just finishes around 12:30, and it'll be a half hour. And then I'd like to have any member who wants a 3rd round to let us know ahead of time so we can kind of plan what we're doing after we get done with this 2nd round we have. I hope there's not too many that want to do that, but if they do, we want to be respectful of everybody to ask all the questions that they can before we finish tonight. And then now, Judge, we're going to take a 5-minute break, but because I was late in announcing this, Senator Durbin has come back from another committee meeting, and he's the next one up, so I want to have it just be 4 minutes and 59 seconds.
Yes, sir.
Recess.
This is the third day of the Senate Judiciary Committee hearing, the confirmation hearing for Judge Neil Gorsuch for the Supreme Court. Second day of questioning from senators. There are 20 members of the Judiciary Committee, 11 Republicans and 9 Democrats. Yesterday they did half-hour rounds. Today, 20 minutes of questions for each member. As you may have heard from Chairman Grassley, a possible third round. Just a short break here, 5 minutes. And then at 12:30, the committee will take a half-hour break, and we'll have live coverage, of course, throughout the day here on C-SPAN 3. Just to let you know about our other coverage today, we are watching the House Rules Committee, which came into session about an hour and a half ago. They are working on the Republican health care plan, and they will be working on that throughout the day. That'll come up for debate and vote tomorrow on the House floor. You can follow coverage of the House Rules Committee at cspan.org. The House in session tomorrow beginning at 9 o'clock Eastern.
Senator Durbin, it's your turn now.
Mr. Chairman, I ask consent to enter into the record 7 articles relative to this hearing.
Yeah, without objection, your articles will be entered in the record.
Thank you. Judge Gorsuch, I sat here yesterday for hours, not nearly as many hours as you sat here, until I reached the point where I could finish your sentences and complete your answers before you. My Republican colleagues assumed the well-known courtroom strategy of never asking a question that could hurt their witness and made every effort to humanize you so that we know your love of fly fishing and rodeos and family. I know that senatorial assignment. I've been there myself. So the Democrats on the committee pressed you for answers to harder questions and tried to peel back your professional and carefully guarded persona so that we might understand whether there's any chance there's a beating heart and an independent streak in Donald Trump's most important decision of his nascent presidency. We were given this public hearing to develop an insight into what it was that made your record so attractive to the Federalist Society, to the Heritage Foundation, and to President Trump. You fended off most questions of substance, so we turn to your written opinions. I'm sure the press and public are puzzled out there why we spent so much time talking about a truck driver named Alphonse Madden, who was fired and blackballed from ever driving again because he was faced with what Senator Franken correctly called an absurd choice of freezing to death or endangering the lives of innocent motorists by driving a disabled truck on the interstate. Many of us still can't understand how 7 judges could look at those facts and the law in the case, and only one, Judge Neil Gorsuch, come down on the side of the trucking company that fired him. Now we have another question that's been raised, and it relates to the Individuals with Disabilities Education Act. It's a landmark law. It mandates access to public education for students with disabilities. The National Education Association took a close look at your record in these IDEA cases. They found that in 8 of the 10 cases to come before you, you ruled against students with disabilities. Furthermore, in one of the 2 cases in which you sided with the student plaintiff, you wrote a concurring opinion, quote, expressing your personal belief that IDEA provides only limited rights to students with disabilities, end of quote. That pattern is troubling. Your opinion in Thompson R2J School District versus Luke P. In this case, the school district appealed the district court's ruling that the district failed to provide a severely autistic child with the educational services guaranteed to him under IDEA. The court ordered the school district to reimburse the cost of a private residential school placement for the child. The district court relied on the expert testimony of autism specialists, psychologists, and occupational therapists to reach that conclusion. They reached the conclusion, quote, the nature of Luke's problems required a residential placement, and, quote, that the reinforcement and consistency Luke needed to make educational progress could not be achieved in a regular school setting at the time. You reversed this district court ruling, and in doing so, you rejected not only the judgment of the federal district court, but also the judgment of a hearing officer and the Colorado State Administrative Law Judge. You asserted that, quote, the assistance that IDEA mandates is limited in scope, end of quote, and that it only requires, quote, the creation of an individualized program reasonably calculated to enable the student to make some progress toward the goals within that program. You also said, and I quote directly from your opinion, from this direction we have concluded that the educational benefit mandated by IDEA must merely be more than de minimis, end of quote. This morning, the Supreme Court ruled on that standard that you established in the case. Here's what they said. In the case of Andrew F. versus Douglas County School District, a unanimous decision by the Supreme Court written by the Chief Justice. Quote, when all is said and done, a student offered an educational program providing, quote, merely more than de minimis, close quote, progress from year to year can hardly be said to have been offered an education at all. For children with disabilities, receiving instruction that aims so low would be tantamount to sitting idly awaiting the time when they were old enough to drop out. The court went on to say, the IDEA demands more. It requires an educational program reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances." End of quote. It's a powerful decision. It's a unanimous decision. It was written by the Chief Justice of the Court. It is an issue which we need to face in America with the incidence of autism and children with severe disabilities. Why? Why, in your early decision, did you want to lower the bar so low to merely more than de minimis as a standard for public education to meet this federal requirement under the law?
Senator, I really appreciate the opportunity to respond to that because I just saw the opinion was handed to me as I was headed to the bathroom a moment ago. I guess it was just handed down. Let's start with the Luke P. case and work forward from there. Luke P. Was a unanimous decision by my court. It included on the panel of 3 judges an appointee who happened to be appointed by a Democrat president. There was no dispute in my court about the applicable law, and there wasn't because we were bound by circuit precedent, a case called Urban versus Jefferson County, 1996. That said that the appropriate standard was de minimis. It had to be, the educational standard had to be more than de minimis. That's the law of my circuit, Senator. And I've been asked an awful lot about whether I abide precedent and whether I always like the results I reach. Here's a case for you.
But I might
Senator,
add,
Senator, if I might finish.
Sure, of course.
I'd appreciate the opportunity to finish this. If anyone is suggesting that I like a result where an autistic child happens to lose, that's a heartbreaking accusation to me. Heartbreaking. But the fact of the matter is I was bound by circuit precedent, and so was the panel of my court, and had been bound for about 10 years by the standard in Urban versus Jefferson County. Now, Senator, there are other cases where, again, unanimously, my court had ruled for children with disabilities under this law. School of Deaf and Blind, another Jefferson County case, are examples where I joined, participated, or wrote in idea cases for the family under our binding standard. I understand today that the Supreme Court has indicated that the Urban standard is incorrect. That's fine. I will follow the law. Now, sometimes, I think it was Justice Jackson who said, just because I made a mistake unknowingly yesterday doesn't mean I should make a mistake knowingly today. I'd invoke him here. If I was wrong, Senator, I was wrong because I was bound by circuit precedent, and I'm sorry. But I'm trying to apply the law, and I can tell you that we were doing it unanimously in all of those cases. And the Supreme Court is our boss, and we respect their last word. They are final.
Judge, in 8 out of 10 cases that came before you, you ruled against the students with disabilities.
I'm sure there were unanimous panels.
And the
Senator,
difference in this case, is about a word. We know that words are important, and they can make a critical difference in a person's life. You can ask Alphonse Madden that question. The word that you inserted into the circuit standard when it came to these cases was merely. Merely. I would say most people reading that would say you have pushed the de minimis statute even further down the standard pole. And it was that word, merely more than de minimis, that was specifically overruled by the Supreme Court. So my question to you is, if you wanted to just stick with 10th Circuit precedent, you felt your hands were tied, why would you add the word merely to modify that?
Senator, all I can say is what I've said to you before, which is a unanimous panel of the 10th Circuit following 10-year-old circuit precedent, including Democrat colleague. I don't view my colleagues as Democrats or Republicans, followed our circuit precedent. And these cases have been decided unanimously. I think of all of them, if I had to guess, that you're pointing at. And to suggest that I have some animus against children, Senator, would be mistaken.
Judge, please, I'm not suggesting that. You are,
Hear it.
what I'm basically saying to you is, I can only look at your court opinions, the words you write, because like many nominees, you are careful in your testimony before us. And we have to look at your words and try to look into your heart with these words. And when I look at that word merely, it troubles me. Do I believe you love your family and love children? Of course you do. But when it comes to applying the law to a truck driver blackballed for life from driving a truck, when it comes to applying the law, when it comes to a family, I cannot imagine the pain they're going through with an autistic child. I want to try to understand what Neil Gorsuch's heart is leading him to. You've told us time and again, no place for my heart here. This is all about the facts. This is all about the law. I don't buy that. I don't think that the decisions of courts are so robotic, so programmatic, that all you need to do is to look at the facts and look at the law, and there's an obvious conclusion. If that were the case, there'd never be a dissent.
Senator, there was no dissent in that case.
Well, in other cases, there have been dissents, and you've written them. And the point I'm making to you, like the case with Trans Am, is we're looking for an insight into your values and your judgment. And it's hard in this kind of hearing to get close to it. Let me take you to an issue I raised yesterday about your mentor and supervisor at Oxford, Professor Finnis, who, as I understand it, helped you write your doctoral, or at least moderated the writing. I've never gone through this experience, the writing of your doctoral thesis, which led to the publication of a book on euthanasia. Is that correct?
Senator, he was my dissertation supervisor. He wrote none of my book, and I've written none of his work.
Would you say he gave you kind support through draft after draft?
Absolutely,
That's
as every
exactly
good
what you said.
dissertation supervisor would do.
So I guess what I'm driving at is this. There is a statement which you made in that book, which has been often quoted, and I want to make sure that I quote it accurately here today. Give me just a moment to make sure I find it. It relates to the taking of life. I'm sorry, I'm having difficulty finding it on this page. And I quote, "The intentional taking of human life by private persons is always wrong." That was a statement that you included in your book, correct?
I believe so.
I believe so, too. How could you square that statement with legal abortion?
Senator, as the book explains, the Supreme Court of the United States has held in Roe versus Wade that a fetus is not a person for purposes of the 14th Amendment. And the book explains that.
Do you accept that?
That's the law of the land. I accept the law of the land, Senator, yes.
I think that's an important element to bring into this, because when you were questioned by Senator Coons about this whole area and asked why you would express an opinion, you said, "I wasn't a judge at the time, I was a commentator." So that's another brief opening of a narrow door here to an insight into what you were thinking. And I wanted to have some clarity on the record when it came to that. Sure. Thank you for that clarification. Let me ask you about the Sixth Amendment. In 1961, Clarence Earl Gideon, accused of stealing money from a pool room cash register in Panama City, Florida, asked for a lawyer. His request was denied. He represented himself and was sentenced to 5 years in prison for petty larceny. Took his case to the Supreme Court, which held unanimously that the Sixth Amendment entitled Clarence Gideon to a lawyer. In 1963, the retrial took place, and then represented by counsel, Mr. Gideon was found not guilty. Judge Gorsuch, do you agree that the Sixth Amendment right to counsel is fundamental?
As recognized by the United States Supreme Court in Gideon versus Wainwright, Senator, yes.
Have you ever written an opinion finding that a defendant's Sixth Amendment right to effective assistance of counsel was violated?
Oh, I'm sure I have, Senator.
You've offered 52 opinions that discuss the Sixth Amendment generally, according to the Stanford Law Review. In none of these did you find that an attorney provided ineffective assistance of counsel in violation of the Sixth Amendment. Further, according to the Stanford Law Review article, you've dissented 4 times in Sixth Amendment context, each time with reasoning that favored the government. I'm concerned that whether you appreciate the importance of this fundamental right. Let's take the 2009 case, Williams versus Jones. Mr. Williams was offered a plea agreement of 10 years. His lawyer threatened to quit if he accepted the agreement. He advised Mr. Williams, if you took a deal and pled guilty, that would be perjury. That was clearly false, a statement by his lawyer. Mr. Williams relied on that misinformation from his lawyer. He lost at trial and was sentenced to life in prison without possibility of parole. When Mr. Williams' case came to the 10th Circuit, you were the lone dissent. Your colleagues, Judges Kelly and McConnell, both Republican appointees, disagreed with you. And then in 2012, the Supreme Court disagreed with you too. In Lafler versus Cooper, Justice Kennedy wrote the opinion holding that, quote, prejudice can exist if loss of the plea opportunity led to a trial resulting in conviction on more serious charges or the imposition of a more severe sentence. The Supreme Court noted that 97% of federal convictions, 94% of state convictions end in guilty pleas. So the accused, even before a trial, must have the competent guidance of an attorney in deciding whether to take a plea deal. In light of Lafler versus Cooper, please tell me what you feel about your lone dissent in Williams versus Jones.
Be happy to. So, Senator, under the Sixth Amendment Strickland test, before you reverse a conviction or a plea deal, you have to find 2 things. First, you find whether there's ineffective assistance. But that's only part of the equation, because the Supreme Court, Justice O'Connor said, we don't reverse where there's no prejudice. So you have to show prejudice as well, ineffective assistance plus prejudice before reversal occurs. So oftentimes you'll have cases where there was ineffective assistance, but at the end of the day, you can't say there was a harm or a foul. Now, that's a counterfactual hypothetical that you have to ask yourself, and it's a hard question.
Did you feel there was ineffective assistance in the Williams versus Jones case?
In Williams versus Jones, the question was one of prejudice in my mind, as I recall.
You said there were 2 tests. I asked you about the first one. Did you feel that this defendant had ineffective legal assistance?
I don't recall what I said on that subject. What I do recall saying is whether there was or wasn't ineffective assistance with respect to providing the plea deal, communicating it to the client. The gentleman had a fair trial, and he had what everybody admitted was a full and fair trial.
But that wasn't the point of the case, not in that case or in Lafler. And the facts say on ineffective assistance are clear. His lawyer threatened to quit if the defendant accepted the plea agreement and advised his client that if he took a deal and pled guilty, that would be perjury. That was false. That is, in my mind, prima facie, ineffective assistance. Was there a prejudice? Oh, I think there was. A choice between a plea deal of 10 years or life in prison?
And Senator, the question was whether there's prejudice in light of a fair trial that took place. And that was the question that the court had to consider. I think I accepted that there was deficient performance or ineffective assistance. And the question was one of prejudice. And the Sixth Amendment is about a fair and free trial for all individuals. And this gentleman, by everyone's admission, had one. He admitted he had a fair trial.
But that's
so,
not the point.
Well,
the point is that he was misled by the incompetence of his counsel to turn down a 10-year plea deal, misled, led to trial, which might have been fair on its face, and a life sentence at the end of the day. And the Supreme Court clearly, you were the lone dissenter in that case at the circuit level, the
Yes.
Supreme Court clearly decided that you were wrong with Justice Kennedy's opinion that I read.
It was a 5-4 decision by the United States Supreme Court.
And the point?
Closely divided decision, and you're absolutely correct that Justice Kennedy wrote for the majority and said that in the context of a plea deal, even if there is a fair trial, prejudice will be presumed on the basis of a plea that might have been accepted, could have been accepted, that could have averted a fair trial. And that's the standard, Senator. And since the Supreme Court's announced it, I have faithfully applied it.
Thank you. Thank you, Mr. Chairman.
Now, Senator Cornyn.
How you doing, Judge?
I'm doing fine, thank you. Great.
I think you are. I think you are. It's been an endurance test, I know, but I think you're doing fine. Let me just join the chairman, Senator Grassley, in saying that I hope you really will take a look at cameras in the courtroom. You know, a camera like this one hidden behind a facade with just a lens protruding that doesn't move around the room and that just reflects what's happening before the court, I think would serve a similar educational role, would be enlightening to a lot of school kids and adults and others as to how our judiciary actually functions. And I think they may find out how boring some of the cases are if you're interpreting the Internal Revenue Code or something like that. But I think just as I hope people have been enlightened and educated by this hearing, at least some of it, I think there's a lot that people would learn and benefit from in terms of the role that the judiciary plays in our government. And so I just would ask you to, and you've already committed to doing this, keep an open mind and take a look at that. I think there are plenty of examples of state Supreme Courts, for example. I can think of one in particular that has a fixed camera there that people don't play to, people just don't even know is there, that would be very helpful to our general awareness of, again, the role that the Supreme Court plays. So enough about that. So you participated in 2,700 or so decisions?
Yes, Senator. More than that.
And how many cases have you been asked about here?
A few.
That's my impression as well. I can think of maybe less than 5 of the decisions that you have rendered as a federal judge over the last 10 years. We're talking about less than 5 cases. And that strikes me, I'm not criticizing necessarily, but it strikes me as a little bit of cherry picking when it comes to your overall record. And I think you had a discussion with Senator Graham about what the appellate courts have said, or excuse me, the Supreme Court has said about your work. And it's pretty darn good. I think you all were quibbling about whether there was one reversal or none, but I'll leave that alone. Let me ask about the case that Senator Durbin was inquiring about, just handed down from the United States Supreme Court apparently this morning. You haven't had a chance to read that yet, have you?
It was handed to me on the way to the bathroom.
You haven't had a chance to read it. So neither have we. Neither have we. And so I look forward to reading that. I'm sure you do as well. But in the case that Senator Durbin asked you about, that you actually did render a judgment and write an opinion on involving a student with disabilities, that was appealed to the Supreme Court of the United States, wasn't it?
I don't recall.
Well, we checked it out. It
I'll
was.
bet.
And they denied certiorari. And it takes 4 judges, doesn't it, on the Supreme Court to grant a writ of certiorari?
That's right.
And so apparently there weren't 4 judges that thought that that case merited a review by the Supreme Court of the United States. My point is, if people are going to cherry pick, and I'm speaking generally now, not necessarily just this hearing, if people are going to try to cherry pick a judge's decisions and to characterize them as caring or not caring about children with autism or whatever the sympathetic plaintiff would be, and of course they deserve our care and sympathy as a general matter. But if somebody's going to try to characterize your entire judicial career based on the decisions in these handful of cases, when the Supreme Court of the United States has found no fault with them and it's basically deferred to the judgment of the 10th Circuit and your decision, it strikes me as this is kind of an indictment of the whole federal judicial system. If you can go in and cherry pick individual cases and talk about how sympathetic the plaintiff is, you're basically saying, well, I don't believe that the trial was fair. I don't believe the appellate review by the circuit court was fair, and I don't believe that the review by the United States Supreme Court is fair. And that strikes me as a radical view. And I'm not asking you a question, I'm making a statement. Well, the other thing is it completely ignores Congress's role. I bet you can answer this question. If Congress had decided to change the standard in the case that Senator Durbin talked about in the intervening time period, would you have followed that new congressionally declared standard?
Of course, Senator. Absolutely. That's my job, to follow the law that you pass as best we can, the best of our abilities, consistent with our own circuit precedent interpreting the law.
This is what makes my head explode, that somehow we want to blame judges for our failures as members of the legislature. If we see something we think is an injustice or is wrong, it's within our authority to change it as the elected representatives of the American people, assuming we can get it passed both houses and signed by a president. We can change it. So to me, it seems entirely unfair to suggest it's your fault because we didn't act in a way that one or more of my colleagues might feel would be more just and more fair and more appropriate. Let me ask you a little bit. Well, let me clear up one thing, if I can. Hopefully I'll clear it up, not make it more confused. You know, Senator Feinstein, who I admire and respect, and she knows that's true, made, I think, a suggestion that somehow based on an originalist orientation that you would say that the 14th Amendment to the United States Constitution somehow applied to men but not to women. Do you remember that question? Maybe I butchered that a little bit.
I'm not sure that was quite her question in fairness, and I don't think she implied that, and I certainly wouldn't.
Well, let me just ask you, you do believe the 14th Amendment applies to all persons, right?
Of course, by its very terms and its express terms.
So any suggestion that it applied to some but not all persons, you would disagree or reject that suggestion?
The Supreme Court of the United States has made that very clear.
Let me ask you about another topic that was a favorite of Justice Scalia, one that I came to respect personally. Now, when you're a practicing lawyer, or even when you're a judge, people talk about legislative history as if it is somehow a mystical and magical thing that will provide the answers to all questions. But Justice Scalia was pretty much critical of the use of legislative history, or I should say the misuse of legislative history, where statutes were ambiguous. Matter of fact, my able staff has pointed out one story that he apparently invoked in the 1993 case. You may be familiar with this. He said the use of legislative history is the equivalent of entering a crowded cocktail party and looking over the heads of your guests for your friends. So when judges use legislative history basically to find a way to confirm maybe even their own bias or to confirm their outcome in a case, I think Justice Scalia is telling us that that's dangerous territory, and you ought to enter it with caution. So I'd like to have you comment on it, but there was a dissent he wrote in another famous case, Hamden versus Rumsfeld, where he said about the use of legislative history to justify the court's opinion, he said the question, talking about the question in the case, was divisive, and floor statements made on both sides were undoubtedly opportunistic and crafted solely for use in the briefs in this very litigation. He went on to say the handful of court statements that the court treats as authoritative do not reflect any general agreement. They reflect a now common tactic. which the court once again rewards by pursuing through floor speech ipsa dixit what could not be achieved through the constitutionally prescribed method of putting language into a bill that a majority of both houses vote for and the president signs. Before you respond, Judge, I just want to mention one other anecdote. Since I've been here in the Senate, I've actually been on the floor of the United States Senate where we vote to pass legislation, and then a senator comes out and says, and now for some legislative history. I was shocked. But with the loose way that courts sometimes treat legislative history, that, as Justice Scalia said, can reward bad behavior on the part of the legislature. So would you now offer us your views on the appropriate use of legislative history and how judges should review legislation passed by Congress where there is some perceived ambiguity?
I'd be very happy to, Senator. Excuse me. I'd start by saying that a good judge entertains all arguments from all comers. So you read the briefs as presented to you. You don't tell people what they can and can't argue, generally speaking. There are more and less persuasive arguments to be made, but people get to make their arguments. I believe in trial lawyers, for example, getting to try their cases, and appellate lawyers getting to argue their arguments and leaving them space and the courtesy of room to do that. So I don't believe it's my job to tell people how to argue their own cases, presumptuous of a judge. I would say that it's well known, and I think appropriately so, that the law that governs is what this body passes in connection with the House of Representatives and signed by the President. That's the law. That's all that's the law. Nothing more and nothing less. And everything else stitched around it is not law. And it may or may not have persuasive value in interpreting and understanding the law. But it isn't law. The founders and the Constitution prescribed a process for making law. And they made it hard. They made it really hard. That was the part of separation of powers they really believed in. They didn't want lawmaking to be easy because they wanted to preserve the liberty of the people. So they divided the lawmaking authority between two bodies. And they required the signature of the president or a legislative override. Tough process. Not the case in every country in the world, or even in every state. So that's what law is. And there are some due process considerations in this area, fair notice considerations in this area that I take seriously. That we charge people with notice of the law, right? Generally speaking, ignorance of the law is no excuse. We assume that it is reasonable for the people to be on notice of all 5,000 federal criminal laws that this body has passed. Is it also reasonable to expect them to know all the floor statements that have been issued about the law? Everything that might have been entered into the record but not discussed by unanimous consent? Is that reasonable? Is that fair notice? Is that due process? And these aren't idle considerations because more often than not, we're talking about a criminal statute. And we're talking about whether someone goes to prison, federal prison, for a long time. And I have concerns about relying on things that are not law and charging people with notice of things that are not law as a basis for putting them in federal prison. That's the concern. So I hope I've addressed your question, Senator.
Well, you have. And senators and members of the House of Representatives don't vote on documents that, for example, the documents that have been admitted here by unanimous consent that nobody's talked about or perhaps even read, or the floor statements, those aren't things that have achieved the consensus, the hard-fought consensus that you talked about legislation having to achieve, and a presidential signature. So I appreciate your speaking to that. There are just a few other cats and dogs here that I want to go over with you. The day you were nominated, you spoke about judges looking backward, not forward, in interpreting the law. Now, I think some people have taken that in a negative sense. They viewed the word backward as somehow pejorative. Those who view history as an inevitable path forward of social progress may incorrectly hear that to mean your approach will not support their goals. Can you explain what you mean by looking backward and not forward? Can you explain why your approach to the law is not hostile to social progress?
Backward doesn't mean backwards, Senator. The role of the judge is to say what the law is, the great Chief Justice Marshall declared in Marbury versus Madison. Our job is to say what the law is. So, for example, in a criminal case, when we're interpreting a statute and whether it permits a man or a woman to be sent to prison, we're charging with knowledge of the law as it was at the time he or she committed his alleged crime. We're saying this is what the law is. This is what it means. This is what it meant at the time you committed your crime. That's backward looking. That's what I mean by backward looking. We resolve cases and controversies over things that happened in the past, disputes from the past, a crime committed, a breach of contract, a business dispute, a landlord-tenant problem, whatever it may be. It's a case or controversy that by the time it gets to the court is in the past. And we're asking what the law was at the time that the events in question took place. That's our job. And we're saying what the law was, what it is.
Is that another distinction between the role of a judge and a legislator?
Yes, we look backwards in this sense, in the sense of looking to historic facts in the cases and controversies between the people that have arisen and saying what the law at that time was and what they could reasonably be charged with notice of. Your job as legislators is, you're not concerned with the history, you're concerned with the future. You're concerned with writing new laws of general applicability that govern our society and our social coordination problems going forward.
Thank you. Judge, there's some members of this body who have suggested that you are hiding your judicial philosophy. That was a claim we heard repeated by at least one member of this committee yesterday. But to me, I don't know what they've been listening to and what they've been paying attention to. If that's their conclusion, I don't think they've been paying attention to the proceedings here over the last day and a half or your testimony. Over the last 3 days, we've heard a description of your legal philosophy and the reasoning behind it time and time again. You discussed, for example, precedents with Senator Feinstein. We heard you discuss the history and legal test of the Religious Freedom Restoration Act with Senator Coons. You and I discussed the importance of faithful adherence to the Constitution and statutes passed by Congress, and you talked about this with Senator Klobuchar as well. Yesterday, we heard 12 hours of discussion of your decade of judging, your judicial philosophy, which you described in almost, well, roughly 2,700 cases, hundreds of which were in published opinions, some not. So if somebody has arrived at the conclusion that you've been hiding your legal philosophy during your time before this committee, do you think that's an accurate assessment?
I would hope no one would reach that conclusion, Senator.
I think no reasonable person would reach that conclusion based upon what we've all had an opportunity to see and hear this last day and a half. Thank you.
Thank you.
I think it's work out just right for Senator Whitehouse to go ahead, and then we will adjourn for a recess for 1/2 hour.
Mr. Chairman,
Yes.
May I ask a unanimous consent to make part of the record an interview with Justice Scalia entitled "The Originalist" in January 2011?
Without objection, so ordered. Senator Whitehouse.
Thank you very much, Chairman. Judge Gorsuch, the state of play after our conversation yesterday, as I recall it, is that you would not say that anonymous billionaire dark money is a bad thing in our democracy, and you would not call on the dark money behind the $10 million political campaign for your nomination to reveal itself. Now, if I'm wrong in that recollection, I just wanted to give you a moment to either amend or correct my recollection of those 2 points yesterday.
Thank you, Senator. I believe what I said yesterday is that Congress is the primary organ for lawmaking in our legal order, and that Congress has ample authority and opportunity to pass campaign finance regulation, including disclosure laws. That Buckley versus Vallejo expressly recognizes the power of Congress, especially in the area of disclosure.
And what I was asking you, just to be clear to the point, is whether you saw disclosure as an affirmative value, in the same way, for instance, that you see reliance interests for corporations on the law as an affirmative value.
And Senator, you're mistaken. I never said reliance interest for corporations.
Reliance interests for parties.
That's what I said, Senator. And that's because that's the law, in the law of precedent. We look to reliance interests. And when it comes to the First Amendment,
reliance interests, that's judge-made law. That's the law of precedent.
that's the law of precedent. Yes,
Because the judges follow important principles,
precedent, Senator. We follow precedent.
which
And-
are grounded often in principles. There's more to the law than just what Congress declares, is there not? There's the entire devolution of the Constitution into all of the doctrines that the Supreme Court has parsed it into over the years. That's done without Congress, isn't it?
And one of the precedents of the United States Supreme Court, if you want to call it a principle, I'm not going to argue with you, in Buckley versus Vallejo had to do with disclosure. And the Supreme Court expressly recognized that under the First Amendment, Congress and the states, who've been actually busy in this area, as you know, legislating, have the power to pass laws requiring disclosure up to a point. There comes a point, there is a point that the Supreme Court's also recognized in NAACP, where disclosure can be used as a club.
So let's talk about NAACP for a minute, because twice you reverted to that yesterday. NAACP versus Alabama is the case you have in mind when you say that, I believe, correct?
Yes.
And it suggests, when you raise that in the context of a conversation about dark money, that you find an equivalence between billionaires meddling secretly in our democracy behind a screen of front groups that they've thrown up to obscure their hands, and families in the Jim Crow South whose homes and churches were being bombed, whose sons were being lynched by white mobs in essentially mass racist murders across the South, but particularly in Alabama, in that state, and where the disclosure of their membership in the NAACP would have put them immediately into harm's way. Now, presumably, that is not what you meant. So
Senator,
let me give you a chance to clarify that you don't see those two things as equivalent.
Senator, I never said any such thing, and I wouldn't, and I haven't.
Well, when you
That's a
cite the
false-
NAACP case, it's hard not to revert to its facts, which were
Yes, exactly.
Which were those.
Very important facts.
Yeah.
Every case, every precedent is built around its facts. That's absolutely right. And
So that may not have much application to the case of billionaires secretly meddling in American democracy behind front groups, correct?
Senator, if I might,
Please.
we were talking about disclosure requirements, as I recall.
And that's where secretly meddling comes in. That's why I used that phrase.
I believe we were talking about disclosure requirements and First Amendment doctrine. And I indicated that Buckley versus Vallejo has given this Congress, if it chooses, the opportunity to pass laws in this area expressly. And all I acknowledged is that there does come a point at which one has to worry at the other end of the spectrum under existing Supreme Court precedent, and that is the NAACP principle. And Senator, that's it. That's all I've said.
Great.
I haven't,
I wanted to
and
make
read
that-
anything else into
I
that
wanted to
would
make
be-
that clear.
would be
because
mistaken.
I think there's a very significant difference in the fact.
Of course there is.
Oh, very good. So let me go back into our history a little bit. In 1816, Thomas Jefferson expressed concern about, and I'll quote him here, moneyed corporations which dare already to challenge our government to a trial of strength. And a little bit more than around a century later, Teddy Roosevelt warned, and I'll quote Teddy Roosevelt, that unless the great corporations are controlled by the government, they will themselves completely control the government. Should the Supreme Court, in its decisions, keep in mind Thomas Jefferson's and Teddy Roosevelt's warnings about what can happen when massive economic powers jump the fence to become massive political powers?
Well, Senator, as you know, corporate speech, when it comes to the First Amendment, doesn't receive the same protections as individual speech. There is a difference in the doctrine there. So that's an example, perhaps, of an instantiation in law of some of the concerns you're expressing. Another instantiation or example to me is antitrust law, the Sherman Act, passed by this body and interpreted by the Supreme Court over many years now, trust-busting era stuff. And and it does try to keep competition as an important value in our legal system.
So let me elaborate a little bit on that point, because you have said that before in your decisions in the antitrust realm, that competition is an important value that judges should bear in mind as they're interpreting antitrust law and antitrust precedent. And I agree with you. I think it absolutely is. I think you also said that innovation is another such value, and I agree with you on that, too. My concern is that this Supreme Court right now, at least the Republican-appointed majority recently, particularly the Citizens United group, seems to not admit the possibility that the similar kinds of concentration of power that destroy competition and innovation in the economic market can also take place in the political marketplace and can destroy competition and innovation in the political marketplace. Do you see that principle, that there could be a point where political power is so concentrated that it in effect is crushing the opposition rather than allowing free competition as a potentiality that the court should bear in mind as it makes its decisions?
And Senator, here I think of Buckley again, and its recognition that corruption and the appearance of corruption are legitimate interests that Congress can pursue in legislation. And that is an example of, I think, the principle you're talking about, which Citizens United also speaks of. It says there the record before it didn't satisfy the court that Congress's legislation in that particular case had established a case of corruption. I understand you disagree with that, but it did recognize that corruption in its appearance remains area where Congress may legislate in the future.
So let's go to that point, because they did say that no amount of corporate spending, none, there is no limit on the amount of corporate spending in politics that could lead to either corruption or the appearance of corruption. To me, that is fanciful in the extreme. And they got to that point with three, well, I would say they did fact-finding, which they're not supposed to do, but I don't want to quarrel over that point with you here, because that's not the point of my question. So let's say what they did was they made some presumptions. One presumption that they made was that all this corporate political spending they unleashed was going to be independent of candidates. That was presumption one. Presumption two was that it was all going to be transparent. ExxonMobil was going to put up the ad saying, we hate White House because he's fighting us on climate change, and you should be with us, and everybody would know who the players were. The third is that the back and forth that this would produce would not affect confidence in government. Now, I think that the facts, reality, as it has developed since the Citizens United decision, completely belies all three of those points. All of the major candidates for, or at least most of the major candidates in the last presidential election had what they called affiliated super PACs. I mean, what does affiliated mean? It does not mean independent. So clearly, just on that alone, it doesn't even pass the dictionary test. Clearly, there's no independence. As to transparency, this whole dark money problem belies their assumption of transparency. And public confidence has crashed in government since that decision. For, among other reasons, I think when you are sitting there looking at the TV and an ad comes on that says, vote for Senator Snooks or vote against Senator Snooks, and this ad is brought to you by Americans for Puppies and Prosperity, and everybody looks around and they know perfectly damn well there is no such real thing as Americans for Puppies and Prosperity. There's no real corporation running that. There's no real person running that. It's a screen. It's a front. It's a shell for the real actors behind it. I think that is very damaging to Americans' confidence in their government on both sides of the aisle, which I think is one of the reasons why all three of the major commentators on the Supreme Court have basically described them in the modern age now as instruments of the Republican Party. And I think it also is why the majority of Americans looking at the Supreme Court think they won't get a fair shake there against a corporation. In fact, 36%, more than a third, think that the court will be much more favorable to a corporation than to a person. So the question here for you is, would you be willing, if you came to the conclusion that the independence presumption or the transparency presumption or the confidence presumption of Citizens United were in fact wrong, to reconsider that case?
Senator, I've got a couple of reactions to that, if I might.
But don't lose the answer to my question.
No, I'm going to start with that, but there's one other observation I want to make beyond it, if I might. Okay, thank you. I'm going to promise you what I promise every litigant. And I hear a litigant before me asking for an overturning of a precedent. That's what I hear. And I hear arguments for that. And arguments for overturning precedent include changed circumstances. Okay? And that's what I'm hearing. That's the kind of nature of argument I'm hearing. That's something a judge takes seriously, of course. Always. And any litigant can come to court and argue anything. That's the beauty of our system. I will follow the law of judicial precedent in this area and every other area put to me. I will make no promise for the result in any case. That's not what judges do. We listen to the cases put to us.
And for the record, it's not what I want you to do. What I want you to do is to tell me that if the proper decision is that this was so wrongly decided it should be reversed, you'd be willing to go there. based on proper judicial decision-making.
I will follow the law of judicial precedent in this and every other area, Senators, my promise to you. The other thing I would say that I would like to say is two other things. One is there's room for not just further litigation, Senator, but legislation in all of these areas. If there are changed circumstances that Congress observes, it's free not just to bring a lawsuit, but to pass a bill on any of these areas. And finally, Senator, may I just finish?
You finish, but then let me come back to that.
Of course. The last thing I want to say is I'm distressed to hear you think that judges or the Supreme Court is an organ of a party. That to me is just, I know you feel that way, and that distresses me.
It distresses me too.
And I just don't.
Quite a lot.
I just don't see judging that way. And I don't see our rule of law that way. I don't see Republican judges and I don't see Democrat judges. I see judges. And Senator, I think the rule of law in this country works. And it works so well that to speak like that diminishes what we have. And it is, for me, a failure to appreciate the beauty of our system, that we resolve hundreds of thousands of cases a year, almost always unanimously as judges, that the disputes are limited to a fraction of a fraction of a fraction of a percent, and that once we resolve them through the dispute process of litigation and we have precedent, that settles that problem and we can move on to the next one. It's a miraculous system, really.
In my time that remains, which is getting briefer and briefer, let me make 2 points. One, on the 10th Circuit, I don't believe you hardly ever have party line decisions made by your court. We looked, and I count only 2 in the entire time you've been on the court.
I really appreciate you pointing that out. Thank you.
It's a very different world where you are. When you get to the Supreme Court, now we have these 5-4 decisions that I pointed out, and it's 6-0, one party over the other party's interest at the polls. It's 16-0, corporate interests versus human interests in litigation. There is a point where it becomes reasonable to discern a pattern, and I see a pattern, and it distresses me. Now, the point that I wanted to get back to, I've got 2 minutes left, was your question about Congress can do this. Congress can rewrite these laws. Congress can demand disclosure. Here's the problem. In the same way that a small competitor can be crushed by a dominant business in the economic market, once you let certain political interests achieve the kind of dominance that Citizens United has let them get, they can start to exert disproportionate control over Congress. And now Congress can't do that any longer because there's no longer a fair playing field. If the court can rebuild a fair and competitive playing field, then maybe we can do something about it. But to say to Congress that you should solve this while at the same time the court has put Congress in a position where it can't solve it because the unlimited power and the secret money of these interests is such a powerful and pernicious effect, is something that I'd like you at least to be thinking about as a point if you get to that court. I hope you will take that sincerely. You are quite expert in antitrust law. You understand that principle in the economic sphere. I urge you to consider that Citizens United has caused that to happen in the political sphere. And with that, my time has expired.
I would like to, if I might, just briefly,
You
Senator,
can proceed.
just cheer you up a bit, I hope, about the judicial process. I think that you're right that there are some 5-4 decisions. There are. But what that overlooks, I think, Senator, are some facts that I shared, I hope, with the American people yesterday. That even at the Supreme Court, where they take the 70 or 80 hardest cases every year, where circuit judges have disagreed, and even then, only about 5% of cases get to me. So we're talking about a fraction of 1% of the cases, that they're unanimous with 9 justices appointed by 5 different presidents 40% of the time. It's a remarkable thing.
Look,
should be proud of it.
I
We should be
understand that,
proud of it.
and I get it. But what we have as a right is to have the Supreme Court make a fair decision in every case.
I agree.
Not just 99% of them, but all of them. And I think these 5-4 decisions are a problem. You said earlier that sometimes, I think I'm quoting you correctly, sometimes big corporations can capture an agency. That's a well-known principle of administrative law and of economics. Just let's be sure that our Supreme Court doesn't get to be one of those agencies that's captured on any subject.
Nobody will capture me.
I hope not.
We will recess now until
Wow, that's a good line to recess. on.
until 1 minute after 1. Okay.
It's the third day for the confirmation hearing for Judge Neil Gorsuch.